occupied by them, by the Ministry of Defense. So rental compensation has been made from 1971 to July 2022. By that time, my lord, the LAC 1894 has already been repealed. It has commenced from 1/1/2014. So, my lord, we are seeking for payment of compensation for the occupied land as per the provision of the 2013 Act. So, they are not denying, my lord. The Ministry of Defense in their affidavit at para number 14 has clearly stated that the Right to Fair Compensation Act 2013 has come into force. So there is no question, the question of demanding compensation under the LAC 1894 does not arise. It means that, my lord, we have to be paid compensation for our land, which has been taken away by the central government from our possession without paying any compensation. So, my lord, we have to be paid compensation as per the provision of the 2013 Act.
Yes, regarding the prayer for acquisition of land, you have any submission? Ms. Zairems.
My lord, we just reply the affidavit, the statement made in the writ petition, my lord.
Heard. What is your name?
Lalsan Liana Kiang The, my lord.
This is item number.
Item number 4.
Mr. Lalchan Liana Kyangte, Learned Counsel for the petitioner. Also heard Ms. Zairem Sangpui, Learned Central Government Council, appearing for respondent number
1 to 3.
1, 2, 3, as well as Ms. Caroline, Learned Government Council, appearing for respondent number 4. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners, namely 1, 2, 3 and 4. Seeking expeditious payment of compensation assessed by the District Collector Kolasep in compliance of judgment and order dated to 23/2/2017, passed by a coordinate bench of this court in WPC number 48/2019. Where is the earlier judgment?
Annexure 1, my lord. Page 16 to 83.
16. I'll dictate it in chamber. I'll dispose it of today itself.
My lord. My lord, the second prayer, I would like to make it clear that the second prayer is for direction to pay compensation for the land of the petitioner as per the provision of the 2013 Act, my lord, with all statutory benefits as if it was acquired from 1/8/2022, because the rental compensation has been assessed up to July 2022,
Okay, I'll consider.
my lord. Oblige your lordship.
Item number 2.
You have received the judgments.
In 1951, Supreme Court case SCC 9934.
1951.
SCC 934.
Yes.
It's a short judgment, Lordship. I'd just like to read out it. This is an appeal by special leave against the judgment and order dated so-and-so of the Madhya Bharat High Court in Criminal Revision number 139 of 1950. The appellant Pushkar Singh stood his trial for offences under section 449 and 372 Gwalior Penal Code before the additional city magistrate of Lashkar. The magistrate held that no case was established against him and the sum of money recovered from Pushkar Singh's house belonged to him. The prosecution evidence to the effect that Pushkar Singh borrowed the money from inside and gave it to the police was disbelieved, and it was found that it could not be held that this money belonged to the complainant or pertained to theft committed in his house. As a result of these findings, Pushkar Singh was acquitted. As regards the article of the money taken from the Pushkar Singh's house, it was ordered that they be returned to him after expiry of the period for appeal. The learned session judge dismissed an application for revision made to him by and on behalf of the complainant against the decision of the magistrate ordering that a sum of rupees 463 recovered from Pushkar Singh's house be returned to him. Kaushala Bai, widow of the complainant, filed an application in revision in the High Court of so-and-so, Madhya Bharat, Gwalior. The High Court allowed the application and ordered that the amount of rupees 463 be awarded to the complainant and not to Pushkar Singh. It seems to us that this order cannot be sustained in view of the clear finding of the fact given by the magistrate to the effect that no offence was committed in respect of the sum of rupees 463 and that it did not belong to the complainant. It was on the basis of these findings that Pushkar Singh was acquitted and the amount recovered from his house was ordered to be delivered to him. Unless it was found that an offence was committed in respect of this sum, there was no jurisdiction in the High Court to order the payment of this amount to the Kaushala Bai. We have not been able to appreciate the view of the High Court that although that the stolen property consisted of currency notes, those notes may have been changed by the accused. There is no evidence to support these findings, and unless by due procedure of law the acquittal of the accused is changed into a conviction, the order for payment of the sum of rupees 463 in favor of Kaushala Bai cannot be sustained under the clear provision of section 517 Criminal Procedure Code. We therefore set aside the order of the High Court and restore the order made by the magistrate in respect of the amount of rupees 463 and direct Kaushala Bai to pay this amount to the petitioner. We make no order as to cost in these proceedings. Mainly similar to our case, Lordship.
This 463 rupees went to
way back in 1950, Lordship, yes. And again, I'd like to submit another citation, Lordship, 2025 SCC online, SC 437. Para number 38. 38 and 39. For all the aforestated reasons, we are inclined to allow the appeal preferred by the appellant accused number 3. Accordingly, criminal appeal number so and so preferred by the appellant Nankumar Babula Soni are allowed. His conviction and sentence under section 120B and 411 of the IPC is set aside. Since the gold bar were recovered from the appellant Nankumar Babula Soni, he is entitled to possession of thereof. Therefore, we direct that the seized gold bar, 205 in numbers, be handed over to the appellant Nankumar Babula Soni. In view of the fact that the identity of the seized property, being the stolen property, has not been established, Vijaya Bank is not entitled to the possession of the seized gold. Accordingly, criminal appeal number so and so preferred by Vijaya Bank stands dismissed. We, however, make it clear that the findings are for the purpose of the criminal appeal and will not come in the way of other remedies, if any, as may be available in law to the parties. 2025 SCC online SC 2012.
How many judgments you are
3
saying?
judgment, Lordship. This is the last one with regards to the assess article. Para number 11. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Lordship, I'd like to read it from the top line, that is the 10th line from the top. Simply, it starts from simply. Para number 10.
Yes.
Simply because the amount owed to him matches the amount recovered does not establish that he is the only claimant to the said amount. As such, we hold that the additional district and session judge Mesana correctly took the view that the direct ownership of the said respondent cannot be conclusively established. The appropriate ownership of the sum of money can only be determined after consideration of all evidence and have taken into account the claims and the views of all the other persons and the appellant accused as allegedly played foul with in business. The evidence presented by respondent number 2 to establish his claim over the said amount will have to be considered by the court, cease of the trial in the matter, and then only can a proper decision be arrived at. At this stage, therefore, releasing the mudabal would be unjustified and premature. In that view of the matter, the appeal is allowed. The judgment of the High Court with the particular as mentioned in paragraph number 1 is set aside, and the judgment and order of the court below are restored. By the order dated 21st July 2025, it was recorded that pursuant to the direction of the High Court, private respondents has already withdrawn the amount. It was as such directed that the said amount be deposited with the registry of this court along with the interest accrued thereupon. The registry is directed to transfer the said amount to the custody of the concerned trial court, for which we direct that the private respondents to forward deposit before the trial court the original currency note should they still be available with him. Once that is done, the amount deposited by him in terms of R is permitted to be withdrawn. Such withdrawal will only be permitted once cross-verification has taken place from the detailed Pachnama that would have been drawn in accordance with the order of the High Court. So in my humble opinion, Lordship, if the...
From where the amount was seized?
Lordship, the police during the course of investigation has forced the petitioner to surrender the money to the police station.
Where was the money?
The money, it was, Lordship, he had borrowed some from his friends and relatives.
So it was seized in cash.
It was seized in cash, Your Lordship. I have annexed the seized memo also, Lordship.
Where is the seizure memo?
It's in annexion number 1. It was in 3 occasions, but however, Lordship, I'd just like to submit that on one occasion it was seized from another person, but he was not among the accused.
No, where is this?
Annexion number 1, page number 13 is the seizure memo. Serial number 4, property seized on 16/3/2019, time 2 p.m., Khoswal Police Station.
From who?
The petitioner name is H. L. Ramoya. The name written there, yes.
Okay. From your possession?
Yes, from my possession, Lordship. The amount seized on that day is 21 lakhs 70,000.
Yes. Yes, Mr. Zaramchana.
Yes, Mr. Lordship. One thing, first of all, Lordship, I'd like to place before your Lordship for consideration is whether the present petition itself, Lordship, can be entertained in view of the fact that, my Lord, they now have not challenged the original order, my Lord. If I may now take your Lordship to the original order, which releases that sum of money to the petitioner here in Lordship, page number
No, but that was an interim order.
22, my law that what cannot be done directly is not permissible to be done obliquely, meaning thereby whatever is prohibited by law to be done cannot legally be effected by indirect and circuitous contrivance on the principle of quanto aliquid prohibito et omne per quid defecto.
No. Do you have any authority which says that order passed under section 457 is not an interim order, it is a final order? On that point, apart from
I'll
your
rely,
side-
my lord. I rely on the provision of CRPC itself, my lord. 457, along with the order wording itself herein, my lord.
Okay.
That doesn't say this will be subject to the outcome of trial, my lord. Nowhere have it been mentioned that this order will be subject to the outcome of the trial. Even if, my lord, now the acquittal order doesn't even say that the seized money will be made absolute. Even if that is not there, my lord, then even so, my lord, even so, the return, the recovery of the money back to the bank will still be very valid, my lord. And now, my lord, since that itself, my lord, is not now challenged, I'd like to rely on one judgment, my lord. 2010, Volume 1 SEC, Lordship. 2010, Volume 1 SEC, 756. Paragraph number 22, Lordship. 2010 1 SEC 756, paragraph number 22.
Yes.
If I may read, Lordship.
Yes.
It is a settled legal proposition that challenge to consequential order without challenging the basic order. Statutory provision on the basis of which order has been passed cannot be entertained. Therefore, it is a legal obligation on the part of the party to challenge the basic order, and only if the same is found to be wrong, consequential order may be examined.
So which one is the basic order here?
The basic order is this one, my lord, 457 order, my lord, which they have not challenged till yet, my lord. And without challenging this one, how can now they say that this order, which says that the seized money return will be made absolute, can be challenged, my lord? That cannot now be challenged, my lord. Even if that is, my lord, struck down today by lordship. And this order 3/2/2022 will still subsist, my lord. Very valid, my lord. And this now attained finality. It was passed way back in 2020, my lord. 6 years already passed by now, my lord. So,
Whether the trial court anywhere made any observation that this money belongs to bank?
that in the final order, my lord, they have not entered into that. They only
And while passing the order under 457, whether they made any observation that this money belongs to you?
if I may take a look to page 23, my lord,
Yes.
of the petition. The first page, the first line, my lord. Hence, the seized currency amounting to rupees so and so belonging to the petitioner bank. So, they come to the conclusion that it belongs to the bank.
On what basis it came to this?
That, my lord, is not elaborated herein also. And that they have not challenged also, my lord. If they are aggrieved with this order, my lord, if they are to say that that money doesn't belong to the bank, it belongs to them, they have to challenge this order, my lord. Which says this specifically says that it belongs to the bank, my lord.
Okay.
My lord. And, my lord, for that now. If I may take lordship to the petition itself, my lord.
Just a minute. In 2019 citation, which paragraph you were relying?
1944, your lordship.
Okay.
And now, my lord, if I may take lordship to paragraph, page number 9 of the petition, my lord. Or rather 10, my lord, 10. In my copy, it's 10, my lord. That's a prayer portion, my lord. Here they have not, my lord, prayed for
Yes.
release of the same to them, my lord. If I may read, lordship, in the premises, it is most humbly prayed that your lordship may graciously please to admit this petition, call for records and issue notice to the respondent to so as to why the claim of the petitioner for release of the should not be released and that should not be modified. They only pray for issue of notice, my lord. What is not prayed, my lord? It is Lord.
They have prayed for modification.
Only issuance of notice, my lord. That's already done now.
May also prayed for modification. They have not stated how to modify it. But they
So
have,
actually, my lord, what is not prayed for cannot be granted, my lord. That's a settled position of law. Sorry, my lord.
okay.
So for that, my lord, I have citation if required, my lord. 2011 3 SCC 456 436.
Anything else? State has to say, state is a party. But it is you who seized the money.
Yes, it's with the direction of the court.
Is it bank's money or petitioner's money?
From the order, we can see that the court has written that the money belongs to the bank. That is what we have seen.
In the custody order, Jimma order. Okay.
And now, my lord, one citation which I will like to place regarding that what is not regarding the pleading cannot be granted, my lord. Will it be required? 2011-3, 436, para 55, man. Para 55.
Okay.
Relief not claimed cannot be granted.
I heard Miss H. Lalmal Swami, learned counsel for the petitioner. Also heard Mr. C. Zoran Chana, learned senior counsel, assisted by who is assisting?
Me, sir.
Isaac Lalrenbrother.
Also heard Miss Linda Farmwell, learned public prosecutor. Hearing concluded, judgment reserved.
Obliged.
Obliged.
Item number 5.
Give these books and this to in chamber.
Lordship, this item may kindly be taken up day after tomorrow, my lord. I now have one fixed item before court number 1, my lord.
We'll fix it and take up it in next week on request of learned counsel for the learned senior counsel for the petitioner, which is not opposed to by learned counsel for the respondent. Let this matter be listed on 7th of May.
Highly obliged, your lordship.
Item number 6.
Here we have to appoint one legal aid counsel.
Yes, Your Lordship, I believe that the learned trial court copy also have to be called for.
No, this appeal is yet to be admitted. So it is registered on the basis of an appeal petition directly from jail. So some legal aid counsel have to be appointed.
Your Lordship, my case has to be appointed not from the legal aid with Your Lordship.
What is the difference?
There's a separate list for the legal aid counsel. So usually they used to be appointed from the.
No, why legal aid counsel cannot be appointed?
They can be appointed, but then that's.
The jail appeal has been registered. Na? This jail appeal has been registered on filing of an appeal petition by the appellant Rohen Lal Chand Hima. Before that, right, heard Miss Mary L. Kyangte, learned additional public prosecutor. This jail appeal has been registered on filing of an appeal petition by Rohen Lal Chand Hima, who has been detained in Central Jail, Lizon, where he is serving out his sentence. Stop. The appellant has impugned the judgment dated 20 1/2026, passed in criminal trial number 706/2023, whereby criminal trial number 706/2023 by the Court of London, which court has Court of London, special judge, learned judge, special court, NDPS Act, Aizol, whereby the appellant was convicted under section 20B 20 small b small to c of the NDPS Act, and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh in default of payment of fine, to further undergo simple imprisonment for 10 months. Amicus list is there. There is a separate list.
No, that's only this legal aid council list only. We have more Amicus list.
Any legal aid counsel is present in the court. Amicus or legal aid counsel is present in the court. Yes, what is your name?
Lần ngày sẽ pha này.
Let her be the. Since this is a appeal registered on the basis of appeal petition filed by the appellant who is detained behind the bars, and amicus curiae has to be appointed to pursue his appeal, to defend his cause in this appeal. Accordingly, Miss C.
Lần ngày sẽ pha này.
C. Lal Saki Fanai is hereby appointed as amicus curiae for the appellant. Let the trial court records be requisitioned. Registry to take steps for requisitioning the trial court records. Let this matter be listed. Let the copy of appeal petition as well as the copy of the impugned judgment be furnished by the registry to the learned amicus curiae. Let this matter be listed after receipt of the trial court records after 2 weeks on a date to be fixed by registry.
Item number 7. Please, Your Lordship. My Lord, this is an appeal against the judgment in order dated 23/2026, passed in title suit number 7 of 2019. The case is being listed for the first time. Notice may be issued. There is no delay.
Okay. heard Mr. Lalfakwama,
My Lord.
learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure, read with order 43 of the said code, and as well as section 17 of the Mizoram Civil Codes Act 2005, has been filed by the appellant Shri F. Zatavna, impugning the judgment and order dated 23/2026, passed in title suit number 7/2019 by the Court of Learned Civil Justice Senior Division Number 1, Aizawl. You were the plaintiff?
I was a plaintiff. Yes, I
Appeal-
was a plaintiff.
Your suit was dismissed or what?
It was dismissed, my lord. What happened was that this is a property dispute.
Whereby the suit, title suit filed by the present appellant was dismissed. Issue notice to the respondents. Since Miss Caroline Leonard, Government Counsel, has appeared for respondent number 1, 2 and 3, no formal notice need to be issued to the said respondents. However, with regard, in respect of the respondent number 4, the appellant shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days of the date of this order, returnable on 29th of May. Let also this stop 29th of May. Stop. This appeal is admitted. Stop. Let also the records of the title suit number 7/2019 be called for from the trial court, concerned trial court. The registry shall take steps for requisitioning the records. List this matter again on 29th of May.
Deeply obliged.
Item number 8 to 24.
May I please, Lordship?
May it please your lordship.
Here I am appearing for the respondent and HIDC in all the series of cases.
For you are appearing for respondent number?
5, 6, 7, 8.
Mr.
5, 6, 7, and 8.
What is the matter here?
The matter pertains to the deduction of the compensation amount. My lord, the petitioners were earlier given compensation under rehabilitation and resettlement under the 2013 Act, Right to Fair Compensation, Transparency, Inland Acquisition, Rehabilitation and Resettlement Act 2013. However, the state government had issued a notification thereafter before the payment, and wherein they decided to apply the guidelines of a JICA. JICA is a funding agency, Japan International Cooperation Agency, and the amount of compensation to be received by the petitioner was greatly reduced. So the petitioners are before this court challenging the validity of the JICA guidelines and whether the act of a parliament can be override by the guidelines of a funding agency, my lord. So it will require some hearing, and if it can be taken up for admission hearing after 2 weeks, my lord, if my learned friend is agreeable.
Why it has come up in orders
My Lord,
column?
as per the order dated
Because
23
some affidavits are to be filed in the previous
are
court
to be
days.
filed.
Ah.
Exactly.
Lordship, I'm appearing in item number 11. I have filed my reply. I have given time for filing reply to the affidavit filed by the state government.
No, as per the order dated 23/2/2026,
Order dated?
my lord, in item number 23 and 24, time was granted to file application for impleadment of the administrator. In item number 23 and 24.
Lordship, I am appearing on behalf of my senior Mr. Johnny, who is the counsel for the petitioners in item 23 and 24. However, he is on medical leave today, Lordship. Correction.
And my lord, in item number 22, prayer was made for filing of the rejoinder affidavit by the writ petitioner.
Lordship will appearing on behalf of my senior Mr. Sila
No,
Raza,
just
for
a
item
minute.
22. Will
Just a minute. In item number 23 and 24, what was directed?
My lord, time was sought for to file application for impleadment of administrator.
My lords, there, in item 2324, the respondents, my lords, one of the respondents, the title was wrong. That was modified by the council in that item. So that, only to that limited extent, my lords. That correction, I think, has been made. Has been made, my lords. So that, so my lords, no further action is required on that, on those two items.
Title means?
My lords, I believe that one of the respondents, my lords, the district, my lords, the name of the district, my lords, that had been changed. It was wrong earlier. That's been rectified now, my lords.
No, but
Perhaps in the order it reflects
But the
instead
order
of
it-
Kala, they wanted to implead the administrator. In the order dated 23/2,
in order dated
It is-
23 to 2026.
26.
26.
It reflects, my lord, they desire to implead administrator instead of Kala. In item number 23 and 24. That is WPC number.
It was already, corrections was already made, Lordship.
So there is no need for impleadment.
No.
My lords, the authority is the same. It's just the term which has been used from Kala to administrator.
And in item number 22, my lord, for filing rejoinder affidavit by the petitioner.
My lords, we will not file rejoinder affidavit regarding item 22. So may be listed for hearing.
Yes, Ms. Dinari, you are appearing for?
Yeah, 11. I have already filed against the affidavit filed by the state only.
In item number 17 and 19, prayer of government advocate to file their counter affidavit.
17, 18 to
17 and 19.
17 and 19 what was the prayer?
Government advocate to file their counter affidavit.
Lordship, in item number 17 to 20, we will not be filing a counter affidavit. Judgment
So perhaps, my lords, as the councils are saying, my lord, they will not file any counter affidavit or agenda, etc. Perhaps the pleading to that extent may be completed, my lord.
Yes.
But I have filed an additional affidavit in item number 8, raising, my lord, a question of maintainability on various counts, including having of the alternative forum, as well as
Those are all
disputed-
question of law, so it can be decided at time of hearing.
No, not already additional affidavit has been filed,
Yes.
so Lordship may accept that affidavit for all the my lord items, as I am raising the maintainability in all the my lord cases.
That will be heard in the admission hearing, Your Lordship. You can heard together.
Instead of filing separate affidavit, my lord, I have filed one in item number 8 that may be considered for all the.
No, now
No,
whether
items.
pleadings are complete or not.
Pleadings are complete, my lord.
We don't have any objection, my lords, to the additional affidavit. If the question is only regarding maintainability, my lords, that can be heard at admission hearing.
It all pertains to
Not
the provision of
admit,
law.
we'll admit it today itself.
Yes, my lord.
My lord, leaving the question of maintainability open, my lord.
Yes, fix it for final hearing.
Yes, my lord.
In item number 8, who is appearing?
I am for the petitioners, my lord.
What is your name?
Zoram Chana.
Zoram Chana.
Yes, my lord.
Heard Mr. Zoram Chana, learned counsel for the petitioner in WPC number 31/2025, WPC number 58/2023, and WPC number 67/2023.
And also, my lord, item 12 and 13 also.
Along with WPC number 120/2023 and WPC number 134/2023
And item 14, my lord. WPC 6 of 2024.
and WPC 6 of 2024. Also heard Ms. Dinari T. Azu, the learned senior counsel assisted by
Lalrin Philip.
Sila Philip.
C. Rwal Feli, learned counsel for petitioner in WPC 71/2024.
Yes.
23.
2023, who submits that she has filed the affidavit in reply to the affidavit in opposition filed by the respondents,
State respondent.
state respondent. Who is appearing for 12? Zoram Chana. 13?
12, 13, and 14 taken care of. Now my sort of 15 to 16.
My lords, I appear in 15 and 16 items. Writ petition 7 and 9 of 24.
Also heard
Jordan, my lords.
Mr. Jordan Romin Thanga appearing for the petitioners in WPC 7/2024 and WPC 9/2024.
Lordship, I am appearing on behalf of my senior in item number 17 to 21, WPC number
17 to 21,
57 to
case number
61.
filable. What is your name?
Michael Pachwau. And on item number 23
Also heard
and
Mr.
24.
Michael
Pachwau.
Pachwau appearing for Mr. Zoni L. Tochang,
Yes.
learned counsel for the petitioner in WPC. Write the case number from 17 to 21.
Yes, Lordship. And 23 and 24. Item number 23 and 24.
24. Who is appearing for 22?
22, Lordship, I'm appearing on behalf of my seniors, Mr. Sila Ramzawa.
What is your name?
Stephen Lalwatsaya.
Also Mr. Stephen appearing for Mr. C. Lalram Zawa, learned senior counsel for the petitioner in WPC. Right, item number 22 and 23.
Only 22, my lord.
22. Who submits that there was some typographical mistake. It was typographical mistake.
Yes, yes. My lord, we won't file any rejoinder affidavit.
No, that impleadment petition who had.
It was regarding the other items.
Okay. No, Yatlikibu, who submits that the said respondents would not be filing any affidavit in opposition. No, they would not be filing any affidavit in reply against the affidavit in opposition filed by the state respondent. Learned Counsel for respondent petitioner number petitioner in 23 and 24 in WPC 126/2024 and WPC 19/2025 submits that there is no requirement of filing any further impleadment petition to implead the administrator instead of Kala in the writ petitions filed by the present said petitioner, as necessary corrections have already been made. Stop. Also heard, who is appearing for the government?
I am appearing for Ministry of Road Transport and Highway.
Respondent number?
In some cases, respondent number 4, in
Also heard
respondent 5.
Ms. Zairem Sankui, Learned Central Government Council, and Ms. Linda L. Farmwell, Learned Additional AG, appearing for respondent number 1, 2, appearing for state respondents in all the writ petitions. Also heard Mr. P. J. Soika, Learned Senior Counsel, assisted by, who is assisting? P. M. Nirola, Learned Counsel for the Learned Counsel for the NHIDCL, NHIDCL, who submits that in writ petition number 71 slash,
31 of 2024.
Where have you raised the question of maintainability?
My lord, item number 8, my lord, that is
In writ petition number 31
31 of 2024.
on 2025, the said respondents, the respondent NHIDCL has raised the question of maintainability of the instant
By filing an additional affidavit.
maintainability by filing the additional affidavit.
That may be considered in respect of all the, my lord,
He submits that since all these writ petitions are taken up together, the said plea of maintainability may also be considered in respect of all other writ petitions. It is submitted at bar that this matter is ready for hearing. Hence, these writ petitions are admitted for hearing, subject to leaving the question of maintainability raised by the Learned Senior Counsel for NHIDCL open. Same shall be dealt with by this court during final hearing of the matter. Accordingly, list these writ petitions for hearing when?
After 2 weeks.
After 2 weeks.
After 2 weeks on a date to be fixed by registry.
But can it be a fixed date on 2nd of June, my lord, if not inconvenient? 2nd of June.
It's more than a month. Cannot be.
Well, that's, I require the accommodation from the council as well as from the honorable court, my lord.
Okay, let it be 2nd of June. On 2nd of June. 2nd of June is a hearing day.
It's Tuesday, my lord.
Tuesday.
2nd of June for hearing.
Obliged, my lord.
Obliged. Highly obliged.
Now, Amit, petition number verify koribo.
Here also I am appealing for the NHIDCL, my lord. Respondent number.
Now, where is the cause list?
Seven and 8. Lord, here what I find, my lord,
Yes, my lord. I'm here for the opposite parties in the IA. So the present IA along with the main case is listed for hearing for final disposal. But however, my lord, the leading counsel, Mr. Joseph Lelsan Himarentle, could not appear due to some personal difficulties. So if this matter may kindly come up again as a fixed item on 12th May, my lord, if permitted.
12th May.
Yes, 12th May.
it can also be
For-
fixed
for
on
what-
the same day, my lord,
What
second,
this
my lord.
IA is for?
This IA is for striking out of the name JICA, who has been impleaded as respondent number 9 in the connected writ petition, my lord.
Your Lordship, I am appearing on behalf of JICA, respondent number 4, the respondent number 9.
Okay.
Your Lordship, last hearing, the argument on our deletion application had happened, and the judge has put this for the final disposal of this writ petition and kept our application in abeyance. His preliminary view was that we are not required to be there in this writ petition, but order was not passed, keeping in mind the procedural difficulties, but we may be required to make class statement at the time of disposal of writ petition. So just for the matter of record, we are there whenever the matter is going to be taken for the final final admission of the writ petition or not. We will be there, but the deletion application argument has already been placed, heard by the Honorable Court last hearing.
Heard Miss Rosie
Yes, my lord.
Manlao.
But Mayor, there is my lord, one point in this
Today the petitioner is seeking an adjournment.
That's correct. That's
praying.
correct, my lord. But what I would like to point out, my lord, here, my lord, the competent authority or the administrator is not made a party. It's a principal party because his that authority's orders under challenge, but is not made party. So just notifying before this honorable court, if the petitioner requires, my lord, can be implemented, my lord, for effective adjudication of the matter. Because they are agreed basically with the amount they have received under the award passed under section 3G of the NH Act.
Heard Miss Rosie Manlove Sangi, learned counsel for the petitioner, who submits that since the engaged counsel for the petitioner, Mr. Joseph L. Rentley, has some personal difficulty, she prays for an adjournment. Also, Ms. S. Sharma, appearing for respondent number
9.
Respondent number 9, as well as Mr. P. J. Saikya, learned senior counsel, assisted by Ms. M. Nirola, appearing for respondent number 2, 7 and 8, who submits that, who has pointed out that since the petitioner is aggrieved by the order of the competent authority for land acquisition / administrator, it may be required to be made impleaded as party in this writ petition. Also, Ms. Caroline, appearing for respondent number 3 to 6, Stop. The point raised by learned senior counsel for respondent number 2, 7 and 8 regarding implement of administrator / competent authority.
Competent authority under land acquisition.
For land acquisition is left to be considered by the writ petitioner. If he deems it proper, he may take steps for doing so. Stop. The prayer for adjournment made by learned counsel for the petitioner is hereby allowed after considering the grounds stated by her. Let this matter be listed again on 12th of May.
Can it be again on the 2nd or 3rd of June, my lord? That will be convenient. I'll be there, my lord. And some preoccupation is there on 12th.
2nd June you have already fixed.
In that case, on 3rd, my lord.
It's a DB day, my
12
lord.
some
3rd
pre-engagement is.
Okay, 3rd of June.
3rd of June is a DB day, my lord.
4th of June.
But in all this, the earlier series as well as in this matter also, I am also assisted by Counsel Juding Pui.
The assisting counsel is absent. What is her name?
Zodin Pui.
Sudin Pui. Write her
Zodin
name.
Pui.
Write her name. Okay, we'll reflect her name.
Obliged.
Obliged, my lord.
Item number 26.
May I please your lordship, this is an application of bail application under section 483 of BNSS, read with section 37 of the NDNPS Act 1985 for enlargement of the accused applicant on bail as she was summoned and thereafter arrested on 5th 8 2024 by the Excise and Narcotics Team Lung Lei in connection with excise case number so and so. My lord, on perusal of the charge sheet, it is found that there are two accused such as C. Lalmonsanga and the instant applicant Vanlul Remy.
Whether trial court records have been received?
Yes, my lord, the trial court records have been received. And my lord, there are some misunderstanding in the previous order that my submission was that the co-accused C. Lalmonsanga has been granted bail. And that bail order has not been received. That was my submission, my lord.
Okay, that if you are relying on that order, you have to produce that order.
My lord,
whether now it is with you or not.
No, it is not with me, my lord.
So what is your submission?
My lord, my primary submission will be the grounds of arrest, my lord, in this instant case.
No, on what ground the co-accused has been granted?
That I have no knowledge, my lord. There is, this is the case from Lung Lei. So, my lord, in my annexes...
You can get a copy of that order and produce it before the court.
My lord, the order has not been received.
Here the orders of district courts are uploaded in website or not?
No, my lord. As far as I am concerned. My lord, if I may take you to my annexure.
No, then on what basis you are saying that he has been granted bail?
My lord, the co-accused C. Lalmonsanga, he is the son-in-law of the instant applicant, my lord.
So he is out?
He is out.
You
The
cannot
daughter,
get-
the applicant's daughter has informed us, has informed me that the husband, Seal Al-Munsanga, the accused, the co-accused, has been
Then you
released.
can also collect a copy of the
My
bail
lord, we
order.
have tried, but they cannot give any order because they have no orders with them.
Where is the trial court record? Who granted bail? The trial court?
Trial court, my lord. I
Then
believe
it
it
will
is
be
the
in the
trial
trial
court.
court records. This appears to be the copy of case diary. You have gone through it?
Not yet, Your Lordship.
Give it to me.
But it,
We may fix a short date.
My lord,
We may fix a short date directing the trial court to send the
Your Lordship, if I may, in the last court date, actually that was last week, I forgot the date. In that time, the petitioner was seeking he had submitted a bail application and he doesn't know whether that bail application is rejected or granted. But now, at this moment, the counsel
Submitted
stated
bail
that he doesn't know whether they have submitted bail or not. What he was referring was the bail application for the co-accused. But in that last time, what we understand is that it's the applicant who has submitted the bail application. So there have to be some clarification in that one, whether, because in the grounds which he has stated, he did not plead the grounds of parity, and for what reason that bail application has to be needed. And the only grounds which he has stated
No,
in his
you
application.
preferred bail application before the trial court also,
for the instant
for the
applicant.
present applicant.
My lord, that
They are not very sure of that.
we are not. I'm not very sure of that.
That you have to find out. And you have to, rules requires that you have to also file an affidavit stating therein that whether you have filed any bail application or not. So unless you are sure whether this present bail application is supported by that affidavit.
My lord, in the previous court, I have made a submission that the co-accused bail application was been granted. That was my submission, and in order to get a bail in terms of parity, that was my idea of making an argument in regards of that, my lord. But there was some confusion that that the co-accused, Seal Al-Munsanga, has already been granted and the bail order has not been received. That was my submission, my lord. And as far as I'm concerned, my lord, the instant applicant has also filed a bail application in the trial court, but it was rejected. And I have no copy of such order. Because, my lord, in my Annexure 2, that is in page number 50, my lord, of my application, my lord. That is the notification dated 4th November 2025, my lord. If I may read out, my lord.
Yes, sir.
In exercise of the power conferred under sub-rule 3 of Rule 16 of Mizoram Judicial Service Rules 2006, as amended from time to time, the Honorable Guwahati High Court is pleased to promote the following Mizoram judicial officer in the entry grade of the district judge gatherer to selection grade non-functional district judge gatherer in the scale of pay so and so, plus other allowances admissible from time to time with immediate effect. My Lord, the additional district and session judge has been elevated to district session judge. So due to this, my Lord, the court has not functioned and we could not obtain any documents from the court, my Lord.
Now, whether your
That is the reason why I have made a submission that
whether your
the
bail
accused,
application which you have filed before the district court
my Lord,
is still pending or it is disposed of.
there is, I believe that has been disposed of and it has been rejected. If not, then I would have not come to this honorable court, my Lord.
No, there is a notification issued by the registry in the principal seat, which is applicable, I believe, in the outlying benches also, that whenever you file a bail application, in your affidavit supporting the bail application, there has to be a statement as to whether you have filed any other bail application and what is the fate of that bail application, whether it is pending, rejected. That has to be stated specifically in your affidavit. But
That is-
you have not stated anything.
My Lord, that is the reason why the trial court records has to be, that is the reason why I've made a submission that the trial court records may be relinquished, my Lord.
It is pending investigation or charge sheet has been laid.
Charge sheet
No,
has
Your
been
Lordship,
received, my
trial has
Lord.
been conducted. And the
Then we have not received the trial court records.
yes, only the scan copy.
Only
Actually,
the
in
scanned
last
copy of the
court
case
date-
diary.
Yes,
No,
Your
we don't require trial court records. Even the scanned copy would do.
Yes.
Scanned copy of the trial court records, not
Yes.
only of the case
It
diary.
is here, the trial copy. The scan copy is here. And PW number 1, 2, 3 are examined and cross-examined
But we don't have order sheets.
We don't have.
without order sheet, Your Lordship.
We'll ask the registry to get the order sheets. Then we'll consider.
Yes.
Get that. What is your name?
J.H. Ricky Lalrothfela.
Heard Mr. J.H. Ricky Lalrothfela, learned counsel for the petitioner. Also heard Ms. Vannesyami, learned additional public prosecutor. It appears that the scanned copy of the trial court case record has been received by the registry of this court and placed before this court in terms of direction issued by order dated 9/4/2026. However, on perusal of the scanned copy, it appears that it is not accompanied by the order sheets showing the orders passed in the said case. Hence, the registry is directed to no, stop. Learned counsel for the petitioner has also submitted that in the meanwhile, one of the co-accused, namely, what is his name?
C. Lalmon Sanga.
C.
Lalmon Sanga.
Lalmon
Sanga.
who was also detained in connection with the same case where the present petitioner has been detained, has already been granted bail by the trial court. Hence, perusal of the order, he also submits that the petitioner also filed a bail application before the trial court, and same was rejected by the trial court. In view of the submissions made by learned counsel for the petitioner, perusal of the order sheets, perusal of the orders passed by the trial court on the bail applications filed by the present petitioner as well as the co-accused would also be necessary for consideration of the instant bail application. Hence, let the order sheets, let the scanned copy of the order sheets of the trial court records also be requisitioned. The registry to take steps for requisitioning the same. Let this matter be listed again when?
After a week. My Lord, after a week?
On 8th of May. 8th of May, list accordingly.
Item number 27.
Yes, my Lord, as per the court order 6/4/2026, step has been taken on the respondent number 2 and 3, but the registered ID card has not been received by the registry.
When have you taken steps?
Yes.
When have you taken steps?
After the day after
6/4.
Yes.
Okay. We'll direct the registry to place the postal track consignment report.
Yes, Your Lordship.
Heard, Mr. This is item number
27.
Lalpian
Feda Chongthu.
Changthu, learned counsel for the applicant/appellant. Also heard Ms. Vannesyami, learned additional public
Your
prosecutor.
Lordship, revision is it is a criminal revision case.
Learned counsel for the petitioner. On perusal of the office note dated 27/4/2026, it appears that the AD card, it appears that the service report in respect of notices issued to respondent number 2 and 3 is awaited. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed again on 7th of May.
Oblige, Your Lordship.
Item number 28.
May please, Your Lordship. Your Lordship, this is an application for extension of time for complying this Honorable Court Order dated 17/3/2023 in WPC number 128 of 2029. Your Lordship, the case in brief is that the petitioners, the respondents' petitioners are teaching staff. They were appointed sometime in the year 2002 to 2018. in the upper primary school, Mizoram. And they have approached this honorable court by filing WPC 128 of 2029 for advancement of their career. And this honorable court judgment and order dated 17/3/2023 was pleased to direct the state to consider regularizing the services or to frame scheme of such regularization if so advised. So accordingly, what the state have done so far.
When the order was passed?
17/3/2023.
Okay.
So, in pursuance of that, what the state have taken is that we have framed the Mizoram Government of Mizoram regularization of centrally sponsored scheme, employee scheme 2024. If I may take your lordship kind attention to page number 70 of the IA. This is the judgment and order. I'm just taking your lordship attention straight to the operating portion.
Page number 17.
70. Paragraph number 23.
Yes.
Yes, your lordship, with your permission, may I read? Thus, upon due consideration of the case in its entirety, I find that the grievance expressed by the petitioner association to be legitimate and has merit. Accordingly, the state respondents are directed to consider regularizing the services of the members of the petitioner association against the existing vacant post of government teachers in the appropriate grade, keeping in mind that the experience and training undergone by the members of the petitioner association and the object and mandate of RTE Act, or in the alternative, to sanction a new post as SSA teachers by creating such cadre. It would be open for the state to frame a scheme providing for further terms and conditions in which such regularization shall be done. Such exercise should be completed within a period of 6 months from the date of receipt of the order. Now, I have explained the steps taken. If starting from page number 5 of the application, your lordship. Paragraph number 4.
Yes.
Yes. Your lordship, with your permission, may I jump to sub number 2 of paragraph number 4?
Yes.
That it is respectfully submitted that a meeting chaired by the Honorable Education Minister was held on 22/5/2023, where all the concerned state applicants, respondent departments, the meeting felt it necessary to obtain the advice of the Law and Judicial Department. I'll stop here. In number 3, Law and Judicial Department tendered advice and advised that it is the concern of the state government to decide which directions it can implement and as per the judgment and order. And in number 4, your lordship, the government had already discussed in a meeting held on so-and-so, it was not in a position to bear the extra financial burden due to fund constraint and would have reaching implications to all the CSS besides the present respondents teachers, SSA teachers, hence decided to prefer an appeal. In paragraph number 5, Learned Advocate General was therefore requested to file an appeal. In number 6, In number 6, decision to retract the decision made earlier and not to file an appeal after all was made on 6/10/2023. And Your Lordship, jumping to number 7. Later on, the steps taken was that in the November 2023, the draft letter to the Advocate General to convey about the decision was put up, but since announcement of the Mizoram state election was made on 9/10/2023, file was endorsed to Law and Judicial Development for advice, which was returned on 30/11/2023. And the Law and Judicial Department observation is that MCC does not bar filing of appeal, and that although the period of filing has already lapsed, if good sufficient is closed, so and so, that it might be filed. And in paragraph number 9, there was a strong campaign not to file an appeal from the respondents' petitioners, and ultimately the Chief Minister ruled that let appeal not be filed in the court for now. This decision was based on the scheme formulated by the DPNAR, which is expected to address the grievance of the petitioners. And the next step is that DPNAR conveyed that they are presently contemplating on 2 schemes. Number 1, regularization scheme for CSS, and number 2, a weighted mark scheme for CSS employees. DPNAR further stated that the scheme encompasses the demand raised by the petitioners in WPC 128 of 2019. And in number 11, as per the instructions of the Honorable Chief Minister, Cabinet Memorandum was prepared by the DPNAR for consideration. And I have explained the hurdles that the state have endured in complying with the judgment and order in totality. And with your Lordship permission, may I take your Lordship to that? The complexity is that in present...
Now, whether any contempt petition is pending?
Contempt is pending. I'm coming to that because...
Contempt is pending?
Yes, contempt is pending. Contempt is pending. I'll come to that, Your Lordship. I just want to route through what the states have taken in compliance with this. Substantial compliance is there, but not in totality. So I want to route through that first before I come to that. And Your Lordship, there are complexity in the service conditions of the employees. Number A is that in the present state, there are approximately 20 distinct categories under Samagra Shiksha. Samagra Shiksha, initially at the time of their appointment, it was Sarva Shiksha Abhiyan, that is SSN, but now it's defunct and renamed as Samagra Shiksha, so it's one and the same only. With a total workforce of about more than 6,000 employees, Your Lordship, making the process of reorganization and compliance exceedingly large in scope. And number B, a considerable number of employees have undergone inter-post movement over time. For example, from high school teachers to higher school, from grade 4 to grade D to teaching post. This has created ambiguity in identifying the appropriate appointment for the preparation of the inter-seniority lists. And the employees were appointed without undergoing the standard recruitment process, that is proper channel, etc., etc. Thus, regularization of the employees who was appointed on such conditions requires careful case-to-case examination. Now, it is not our case that we cannot absorb them because they were not appointed by going through standard process. This was already dealt with in WPC 128 of 2019. But what we are stipulating here in this application, Your Lordship, is that it needs a case-to-case examination to scrutinize. And there are more than more than over 6,000
No, what do you want
employees.
now?
Yes.
What do you want?
Now we want now jumping fast forward. We have taken steps, and then we have make a policy, a scheme for their absorption, not only for the SSA employees, but then the CSS employees, all the CSS employees of the state government, under the state government. Now, the hurdles that we have endured, most I have pointed out, and there is a contempt pending as of now. This is contempt number 17 of 2023, and when we are dealing with the contempt, it came to our knowledge, and it is from the discussion that we were not directed in by order, but then we were pointed towards this filing of the application at this belated stage, because we cannot complete in its totality. Now, I have routed your lordship kind attention to the order, the direction. The direction was to make an absorption, and the state will have the liberty to formulate a scheme. Now, substantial compliance is there by formulating a scheme, but the absorption process is not yet completed due to the volume and the case-to-case studies that is required. And I have also mentioned in my application also that now there are some part that is confidential. If your lordship wants to see the status or the correct scenario, we can produce it.
What you want?
We want the extension of time for compliance. It's not that we are not going to comply.
How much time?
We are requesting 2 years' time, your lordship, for compliance.
2 years.
2 years.
Already 2 years have lapsed.
Yes,
3 years.
another, yes, 2 years.
And this amount to reviewing of the earlier judge?
No, your lordship, it does not amount to review.
Why a specific time period was given by? No, if you are requiring any requesting for any modification in the original judgment, it should go before the same judge. That is my first view, if the judge is available. Because it is a kind of review.
Okay. So, maybe the matter can be listed to the same judge.
Yes,
we can make a request.
Mr. Victor.
If your lordship feels that this should be laid before the same judge who is
No, because
the judgment order,
the judgment
I
specifies
have no objection in referring the matter to the
judgment
same
specifies the time 6 months.
Yes, my lord.
After considering all aspects.
Yes, my lord.
That time was given after considering some factors only. So you are seeking reviewing of that time from 6 months to, it will be 2 more years.
2 more years, yes, your lordship.
In addition to 2 years which has already been lapsed. So 6 months to it will be 4 years. So that can be done. That has to be considered by the same judge if the judge is available. That is my view. Because it amounts to altering the original judgment.
Your lordship, I shall make an, with your lordship permission, I'll make an application for listing the same before the
No,
judge.
I may pass that order.
Okay.
That application may not be required.
It will be more appropriate if your lordship pass necessary order. It can be also taken up to RVC because of the availability of bench in this ISOL bench. Because in view of the pendency of the contempt proceedings since 2023, my lord. And moreover, my lord, in general practice, this sort of extension of time was granted within the period of the original stipulated period. Now,
No, whether the IA is having some merit or not, on that I am not making any observation.
Yes, my lord.
Let that be decided by the bench before
Yes, my lord. Fair enough.
which will be ultimately deciding.
Okay.
You can raise those
Yes, my
objections.
lord.
Heard Miss Mary L. Kante, London, Government Counsel, appearing for the applicant. Also heard Mr. Victor L. Ralte, appearing for the all the respondents.
Yes, my lord, all respondents.
All the respondents. This interlocutory application has been filed by the applicant, that is State of Mizoram, in connection with WPC number 128/2019, praying for extension of time for compliance of the directions issued by a coordinate bench of this court, within bracket Honorable Mr. Justice Nelson Silo, bracket close. In its judgment dated 17/3/2023, passed in the aforesaid writ petition. By the aforesaid judgment, the state respondents, within bracket present applicant, were directed to consider the regularization of the services of members of the Writ Petitioners Association, within bracket present respondent, appropriate grade, keeping in mind the experience and training undergone by the members of the Writ Petitioners Association. Further direction was issued to the state government to frame a scheme providing for further terms and conditions on which such regularization shall be done. Stop. It was specifically mentioned in the aforesaid judgment that the directions that the exercise for complying with the directions issued by the court should be initiated and completed within a period of 6 months from the date of receipt of the certified copy of this order by the respondents. Stop. Learned Government Counsel, Ms. Mary L. Kyangte, Learned Government Counsel, appearing for the applicants, have submitted that the state government had initially thought of filing an appeal against the said judgment. However, said idea has been dropped by the state government and it initiated steps for complying with the directions issued by the coordinate bench of this court in the aforesaid judgment. She submits that state government has already formulated a scheme for regularization of the services of
The CSS employees under the government of Mizoram.
SSA.
CSS employees, Your Lordship.
What is CSS?
Centrally sponsored scheme.
CSS employees in the
Under the government of Mizoram.
under the government of Mizoram. However, she submits that considering the complexities involved in complying with the directions of the court in its letters and spirit, the state government would be requiring further time for complying with the said judgment, said directions, and hence she has prayed for extension of
2 years.
2 years time. Stop. it appears that the judgment in question was delivered by a coordinate bench of this court, within bracket Honorable Mr. Justice Nelson Silo, bracket close, and the said bench is available. It also appears that the relief sought for by the applicant slash state government in this interlocutory application, if allowed, may amount to modification of the judgment passed by the coordinate bench of this court. Hence, this court is of the considered opinion that it would be appropriate that this interlocutory application may be considered by the same bench when as the said bench is available, whenever said bench is available in stop. The learned counsel for the petitioner, applicant as well as respondents are agreeable to this proposition. Stop. Accordingly, registry is directed to list this matter for consideration before the appropriate bench, within bracket Honorable Mr. Justice Nelson Silo, whenever the said bench is available here.
My Lord, if I may, in view of the pendency of the contempt case number 17 of 2023, and the petitioners in the writ petition, my Lord, they were now in the verge of their retirement, they were in the ripe age. And
you want a fixed date?
Fixed date, my Lord, either through RVC
Yes,
or...
VC also is.
Because in view of the roster, as far as we can see, my Lord, the appropriate bench, Justice Nelson, we are not aware of his next sitting in this bench. So this may be taken up through either RVC or any other mode. Maybe on the next week, my Lord, 4th of May. By this week, during this week, they can transmit the necessary files.
That directions, I think, this court may not pass because it depends on the roster. For that, you have to make an application to Honorable the Chief Justice. Basing on this judgment, showing your urgency, you may file an application.
That
If that is the case, my Lord, one humble prayer, my Lord, let the IA and the contempt case be segregated.
Contempt case is not there.
Contempt case is not listed, Your Lordship.
Where is the contempt case?
We do not file the IA in the contempt case. We filed
Contempt
in the
case,
yes, in the
yes.
disposed matter. So
I'll come to that, my Lord. It is before this call, my Lord, which direction was made to list both the contempt and the IA together, my Lord. But unless they were segregated by this court, my Lord, it will delay the contempt proceeding.
In view of the order passed herein above, let the contempt case number 17/2023 be segregated from this interlocutory application. List accordingly.
oblige.
My lord, this is bail application filed under section 483 BNSS to release the applicant on bail. He is charged under section 21B of the NDNPS Act.
21B.
Yes, my lord.
How much contraband was seized?
My lord, 200 grams.
Heroin.
Yes, my lord. Suspected heroin, yes. 200.16 grams of heroin.
To 100.16.
Yes, my lord.
Why the trial court rejected your prayer?
My lord, the trial court's order is at page 59.
When were you arrested?
15 December 2025, my lord.
Now, how long it has been? How many days you are behind the bars?
My lord, it's almost 5 months.
5 months. And what is the stage of trial?
My lord, charge consideration is over, and now we have just called the first prosecution witness, who is the seizing officer.
What is your case?
My lord, my case is that, my lord, if I may take your lordship to page 2 of my
No,
application.
just a minute. Before that,
The
rejection order, page.
My lord, rejection order is at page 59, starting from page 59. My lord, we had filed 2 bail applications. One is, the first one is normal application for release of the accused, and the other one is default bail under section 187 of the BNSS Act.
Okay. Then what happened?
My lord, it was alleged that the charge sheet was already received, submitted by the prosecuting agency. My lord, the operative portion is at page 61, para number 5. However, my lord, even during the hearing of this bail application under section 187, it was never proved by the prosecution that it was duly received by the CJM. And it was simply stated that the prosecuting agency had submitted before the CJM, and this bail hearing was before this special judge was conducted on 19 February 2026, and till the date of the hearing of this bail application, the special court, the judge of the special court of NDNPS Act have not received the case record or the charge sheet. It was alleged that it was submitted on 28 January 2026.
Okay.
However, my lord, if I may read at page 61, para 5.
Yes.
From the middle, from the 6th, 7th line. The record, my lord has got it?
No, read from the beginning.
The record, however, clearly reveals that the accused was arrested on 15/12/2025, and the charge sheet was submitted by the investigating officer on 28/1/2026 before the court of the Chief Judicial Magistrate, Sertip, and was duly received and registered on 29/1/2026. Thus, the charge sheet was filed well within the statutory period of 60 days from the date of arrest. However, my lord, presuming that the CJM has received, not admitting that the CJM has received, presuming that it was duly submitted. However, my lord, this is 28/1/2026. It seems that the bail hearing was on 19 February 2026. That means, my lord, a successive order of remand was passed by the CJM, which is beyond its power. that, my lord, for the sake of argument, my lord, that a successive remand order has to be passed after receipt of this charge sheet. Because this bail hearing was on 19 February.
No. When the court has held that on 28/1/26 charge sheet was submitted, on what basis you are countering that
My lord,
this is not true?
because the special judge on this date of hearing has not received the charge sheet.
Then why he has written in the orders that?
That's beyond my power, my lord. That we have to ask the trial court.
No, it clearly, it mentions that it clearly records reveal that charge sheet was filed on 28/1/2026. Whether records have been called for?
No, Your Lordship, the record has not been called. So if the record may be called.
No, what is your plea in this bail application? On what ground you are seeking?
That is one ground, that my lord.
That default
yes.
bail.
Yes, the default bail, because the special judge have not received, till the time of the hearing of this bail application has not duly received the charge sheet. And also, my lord,
If we peruse the order sheets passed in the case, it will be clear on which date. Because
Yes.
if it is received on 28th of January, there would be an order to that effect in the records.
yes, my lord. And at the time of hearing, the learned PP, Serchhip district had stated
Hearing
that.
before the trial court.
Yes, in the trial court.
Huh.
Before the rejection of this 187. It was stated that it was submitted and it was registered in the judicial section. But, my lord, receiving the charge sheet by the judicial section cannot be a bar under section 187 of the BNSS Act. That is,
What is required?
that it should be duly received by the court, the
Yes.
special judge.
Yes, there is a judgment to that effect.
Yes, that, my lord, the prosecution.
You produce that judgment.
Yes, my lord, I will. And however, my lord, I could not produce in my application that it was duly received or neither not received by the CJM or the concerned court. That I could not produce, and if records may be called.
Apart from the default bail plea, is there
Yes.
any other plea?
Also, my lord, violation of Article 22, that grounds of arrest and reasons of arrest was not intimated to the relatives of the accused prior to the arrest or at the time of arrest. It was merely, my lord, if I may take your lordship's attention to page, in the charge sheet it was stated that it was received by Ms. Lal Enkime. My lord, it's from page 17 of the application. The grounds of arrest, and the next page is arrest intimation, and page 19 is the reasons of arrest. My lord, it was duly given. However, this Lal Enkime is the co-passenger of the seized vehicle. Maybe in other cases she might have been the co-accused.
Grounds to it is mentioned.
It's written that she is the wife's sibling's daughter.
No, what is your submission?
That, my lord, if I may read from page 3 of my application at para 3.
Yes.
That the grounds of arrest must be informed to the accused at the earliest. However, the accused applicant were not informed about his grounds of arrest and reasons of arrest either orally or in writing in the language known to him. There is no signature or documentary proof to show that the grounds of arrest were furnished to him and the relatives, and that such action is in gross violation of the constitutional mandate.
No. Where is the notice under section 47?
My lord, the next sentence is the point that I'm trying to make.
Yes.
Even though the arrest court surrender form stated that intimation was given to Ms. Lal Enkimi, who was also the co-passenger of the seized vehicle, Wagoner bearing so-and-so, that the arresting authority did not give arrest intimation, reasons of arrest, or grounds of arrest to the relative of the accused as per the mandate of law. That Ms. Lal Enkimi, to whom the grounds of arrest was intimated, was not even a relative of the accused applicant. She was just a mere passenger.
Lal Enkimi?
Lal Enkimi was traveling with the accused at the time of arrest. She's a co-passenger.
She's not your relative?
Yes, my lord. Also, my lord, the admitting that the grounds of arrest was furnished, also it was not given in the language known to her.
First of all, who is she? She is not your relative, neither your friend.
Yes, my lord.
No, what is your stand?
Our stand is that she is not a relative as per the mandate of the law, that the arrest intimation should be given to the relatives. And however, she is just a mere passenger and she's not living with us, or she's not neither a near relatives who would have given the notice to the relatives of the accused.
What else is
My lord, the next one is that there is serious violations in the sampling of the seized article. My lord, the samples allegedly drawn in the presence of the learned magistrate were marked VL1, VL1A, VL2, and so on, each having an...
To appreciate your submissions, we will require the records.
Yes, my lord, the FSL record is also here at in my application. My lord, here in the FSL record is at page...
No, we'll call for the trial court records.
Yes, my lord.
Scan copy of the trial court records. Yes, Ms. Vanessa.
Yes, Your Lordship. Regarding the intimation, Your Lordship, it is written very clearly that in the complaint sheet that is in page number 14. The grounds of arrest was intimated to the accused person's wife, older sister, daughter. So actually they were related.
What was the relationship?
Accused wife, sister's daughter.
No. Accused wife's sister's daughter.
Yes.
Where it is mentioned?
It's written in the charge sheet.
Okay.
So
still we will call for the...
Yes, Your Lordship.
What's your name? Fanai?
Yes, my lord.
Heard Miss Lal Ghaisaki Fanai, learned counsel for the petitioner. Also heard Miss Vannesyami, learned additional public prosecutor. In this application, bail application, the petitioner has taken plea that the charge sheet was laid in this case before the concerned magistrate beyond the period of 60 days, and hence the petitioner is entitled to get bail on that count. The learned counsel for the petitioner also submits that there has been violation of the mandate of Article 22 within bracket 1 of the Constitution of India in not communicating the grounds of arrest, in writing to the relatives / friends / nominated person of the petitioner. She has also pleaded that even there is flouting of rules with regard to the sampling of the seized contraband, and as such the petitioner she submits that the petitioner is entitled to get bail. This court is of considered opinion that, considering the grounds stated by the petitioner for seeking his bail, the perusal of the records, trial court records, as well as connected case diary would be necessary. Hence, let the scanned copy of the trial court records as well as connected case diary be called for from the trial court. Registry to take steps for requisitioning the scanned copy. Let this matter be listed again on when?
My lord, 30th?
On 13th of May.
No, my lord,
40th.
30th of April, day after tomorrow. It's a scan copy.
Will it reach?
I don't believe so, Your Lordship. If the matter may be listed next week.
Huh?
Next week. That means it will be on 7th, Friday.
7th.
Yes. Yeah. No.
Let this
7 is
matter-
Thursday, yes.
7th of May.
Okay.
Item number 30.
My lord, I'm appearing for the appellant. The appellant has some personal difficulty and he could not appear. There are some landslides in the neighborhood.
No, appellant need not to appear personally. This is
I'm appearing for the leading counsel for the appellant.
Okay.
I'm not even the appellant's counsel, my lord.
You are appearing from whom?
Mr. Lalrem Twanga.
Okay. So you are seeking an adjournment?
Yes, my lord.
Heard. Ms. Laleng, Ms. Fanai, learned counsel appearing for Mr. Lalrem Luanga, learned counsel for the appellant. She submits that the engaged counsel for the appellant could not appear before the court today due to some personal difficulty, and on that ground she has sought for an adjournment. Also heard Ms. Varnesyami, learned government counsel.
Yes, Your Lordship.
Government counsel appearing for
5 to 7.
Respondent number 5 to 7, who does not oppose the prayer of the petitioner's counsel. Hence, same is allowed. Let this matter be listed.
My Lord, if I may add one submission, he stated that he had received the paper book, and if the matter be listed for hearing in the usual course.
Okay. It is submitted that the counsel for the appellant has already received paper book and the matter is ready for hearing. Trial court records are there, no? List this matter for hearing in its usual course.
Deeply obliged.
Item number 31.
My Lord, here I am appearing as a legal aid counsel for the applicant. And this matter was sent for mediation, but unfortunately, there was no settlement. So it has come back. And there is two IAs. There are two IAs, my Lord. One is IA 138 of 2025. That is for condoning the delay of 889 days.
IA number 138.
Yes, IA 138 is for condoning the delay, my Lord. So steps upon the respondent number 6 is not complete, my Lord. So I'll take first steps through speed post, my Lord. Otherwise, the respondent number 7 have filed their objection, the insurance company. And the respondent 1 to 5 are duly represented. Only 6 is
Heard
left.
Ms. C. Tlang Thiang Lima, learned counsel for the applicant / appellant. Also heard Mr.
Arler Ruthfella. My Lord, I am for respondent number 1 to 5, my Lord. And I will be filing WO.
Write his name. What is your name?
Arler Ruthfella, my Lord.
Arler Ruthfella, learned counsel, who submits that he has been instructed to appear for respondent number 1 to 5.
Yes, my Lord.
And would be filing his wakalatnama shortly.
Yes, my Lord.
Lordship, I am appearing for respondent number 7, the insurance company, on behalf of the...
Also heard Mr.
Michael Pachow.
Michael Pachow.
Yes, Lordship. On behalf of my senior, Mr. Johnny, who is the departmental counsel, empaneled lawyer.
Appearing on behalf of Mr. Johnny L. Tochang, learned counsel for respondent number 7, who submits that respondent number 7 has already filed written objection against the prayer for condonation of delay made by the petitioner in this interlocutory application. It is submitted by learned counsel for the applicant that though this matter was referred for mediation, however, during mediation process, no amicable settlement could be arrived at between the parties. Hence, it has come back before this court again. He submits that the notice to respondent number 8.
Respondent number 6, madam.
Respondent number 6 is yet to Who is the respondent number 6?
Respondent number 6 is the driver, my Lord, the driver of the accident vehicle. He is a necessary party, my Lord. The registry was directed to track the consignment, and if my Lords will see the office note 31/2026.
The tracking consignment only says that it was transmitted to their village post office. So,
But it is, the delivery is not reported.
yes, yes, but the report is attached to the office note, my lord. I think it will be there, my lord. I have checked it.
Yes, but it is only transmitted to
Yes, yes,
Ketum.
yes.
Ketum. So you take fresh
I'll
steps.
take fresh steps, my lord.
What was the last line? Yet to be served. And the postal track consignment report of the notice issued to respondent number 6 gives no indication that the said notice was delivered to the addressee. Hence he prays for allowing the petition applicant to take fresh steps on the respondent number 6. The prayer is allowed. The applicant shall take fresh steps for issuance of notice upon respondent number 6 by speed post as well as by usual mode within 7 days from the date of this order. Returnable on.
My lord, may I please? I have already filed VACA for respondent 1 to 5, my lord.
You have already filed?
Yes, my lord.
Okay.
And my lord, what I am trying to say is that I will be filing written objection against the condemnation for respondent 1 to 5, my lord.
Respondent number 1 to 5, we have written somewhere that he would be filing his vakalatnama. That you write, change that line. That so and so respondent number 1 to 5 has submitted that some time is required, some time may be granted to the said respondent for filing written objections against the prayer for condonation of delay filed by the applicant. The prayer is allowed. Then let this matter be listed again on how much time? 29th of May.
My lord.
29th of May.
Yes,
oblige.
List accordingly.
Item number 32.
My lord, as per the last court order, we have received the written objection filed by the respondent. However, my lord, my senior could not appear due to personal difficulty. If this matter may be kindly be taken up after 2 weeks.
Yes.
I have no objection, my lord.
Heard, Mr.
Samuel Lompuya.
What is your name?
Samuel Lompuya.
Samuel.
Yes.
Write his name. Learned counsel for the applicant. Also heard Miss.
Bilal Ramnemi.
Yes. Write her name.
Bilal Ramnemi.
I am looking for it.
Item number 32. It's reflected in the cost list.
B. Lalram Nemi, learned counsel for the respondent. Learned counsel for the petitioner seeks an adjournment on the ground of personal difficulty of conducting counsel for the applicant. The prayer is not opposed to by the counsel for the respondent, hence same is allowed. Let the matter be listed again after a week on a date to be fixed by registry.
Right, madam.
Item number 33.
May it pleases your lordship.
Yes.
Now, my lord, here in this bail application, it is a commercial quantity and This man was arrested on 27/3/2026. Primarily, my lord, I am agitating 3 grounds. Number 1, he was arrested on 27/3/2026 and he was produced before the learned magistrate after more than 72 hours. That is on 30/3/2026 he was produced. My lord, may kindly come to page number 12 for a while. Page 1-2. My lord is there at page 12.
Yes.
My lord will see the date. It is the arrest memo. The date is 27/3/2026.
Yes.
Now, my lord will kindly come to the forwarding report, which is at page number 11, 11.
Yes.
Now, my lord, this is the forwarding report which we got when we applied for certified copy. It is dated 30/3/2026.
Yes.
Thus, it is a violation of Article 22, Sub-Article 2. Because Article 22, Sub-Article 2 says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of the arrest to the court of the magistrate, and no such person.
Where you were arrested?
Yes, my lord, I was coming to that. My lord, the distance between the place of arrest and the magistrate is 2 hours, my lord. It is Southall PS. And my lord, probably the worthy counsel appearing for the state, the learned public prosecutor, would also agree to that, because it is hardly 2 hours, maximum 2 hours. This is within Aizawl. Hence, it is a violation of Article 22, Sub-Article 2. My lord, my next limb of argument for this bail application is at page number 13A. 13A. My lord is there at 13A.
Just. Yes.
Now, my lord, in my lord, for last 2.5 years, whatever case we have done, my lord, in section 47 and 48, this is a unique of its own kind, my lord. My lord will kindly see this 47 notice, which is at page number 13A. This is a printed format. To that extent, it is okay, I understand. Name, father's name, everything. Now, there is one column, if your lordship sees down below on the left hand side, it is detailed ground of arrest. Your lordship has seen that detailed ground. It continues second page also.
Yes.
Now, what is written here? It is a confession written by the accused himself. He was made to write it. This is the translated one. I'll take your lordship to the vernacular also. Detailed ground of arrest. The police seized number 4 shop case from my possession, and I agree to this. The original.
Where is the original?
1-3, the one page before that. My lord has seen. This is written in a cookie language. Now it is detailed grounds of arrest, page 13, if your lordship can see, my lord.
Yes.
It is written in cookie language, which we have translated in English. This was, in fact, the accused was made to write it, and it is more in the nature of a confession than intimation under section 47. This is more in the nature of a confession. The literal translation of this is, the police seized number 4 shop case. My lord, what is shop case? I do not know, my lord, because here the recovery is 2.odd kilograms of heroin. So there is no mention of any contraband, and neither it was by the police. It is The accused is made to write his own ground of arrest intimating himself. My third and final limb of argument is at page number 14, small a, 14A, that is the 48 notice. My lord is there at 14A. Now 14A, it's also the translated, original is it page number 14. I'll just read this, my lord, 14A. Reference such and such PS case number. This is to inform that in connection with above mentioned case, your husband such and such, such and such, such and such, such and such has been arrested. You may engage a lawyer to represent him. His family members are, now my lord, it is, the first paragraph gives an impression that it is written to the wife of the accused. But see the second paragraph. His family members are residing outside the state, and since they cannot come to Southall police station, the information of his arrest has been conveyed to his wife, so-and-so, phone number so-and-so. This intimation is also being provided to the community leaders for awareness. Next line. The content above is explained to the accused in Thaudang language which he knows. Then comes the translated version. This was again written by me. They made me to write it in my own mother tongue. This is the translated portion. The police have seized drug from my possession hand. Accordingly, I have also informed my family members, and I am informed that I can engage an advocate. My wife could not turn up as she is residing in a different state. Therefore, I have signed on her behalf. Now, my lord, whatever little I understand, my lord, the mandate is that 48 notice has to be given in writing, both 47 and 48. Now, I can conceptualize a situation where the family members reside beyond the territorial jurisdiction of the given police station. In such cases, my lord, what the Honorable Court has held is that you send the intimation through post. By post, they could have sent the intimation, and they can also send this intimation to the nearest police station with a forwarding that you intimate it to such and such address. Nothing, no effort whatsoever was made to communicate this in writing to the family members. And strangely, my lord, strangely, both these 47 and 48, it is more in the nature of a confession than in the nature of an intimation of arrest. And moreover, 72 hours of delay is there in producing the accused person from the custody.
Okay.
Now, my lord, my only prayer is that if your lordship, if the learned public prosecutor wants to take instruction, which probably she would, my lord, if your lordship kindly fix it on 30th, my lord, I want to take a chance because my other matter is also fixed on 30th. And last time also, my lord, the worthy counsel for the state had produced the case diary in within one day, my lord. She has produced it. I must be fair to the court, my lord. So, if your lordship can kindly fix it on 30th, my lord. If at all there is any such contingency, if it does not come, we will, some other date may be fixed. But at least, my lord, because primarily what is required is some instruction regarding 47, 48 and that forwarding report. Because on merit, I am not submitting anything. That's my humble prayer, my lord.
Your Lordship, I have some personal problem on the 30th because my brother is getting married on the 1st, outstation.
You suggest another date?
Any day next week.
Okay.
Now, my lord,
you will produce the...
Yes, I will produce.
The case diary. The charge sheet has not been laid.
No, my lord, no.
We'll call for the case diary. Everything will be...
Absolutely, my lord.
Case diary as well as scan copy of the...
No, my lord, case diary probably would suffice.
No, orders of the magistrate, whether...
Oh, orders of the magistrate, yes.
On
yes.
30. Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Miss Mary L. Kyangte, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Dothang Glen alias Len Len, who has been detained behind the bars since 27/3/2025.
No, my lord, that is a typographical error. It is 26.
26/3. 26 or 27?
The year is 26. Year is 26.
27/3/2026 in connection with Saitwal PS case number 28/2026 under section 21C/25/29 of the NDPS Act 1985. Stop. The main contention of the petitioner while seeking bail in this case is that his fundamental rights guaranteed under Article 22 within bracket 2 of the Constitution of India has been violated in this case, inasmuch as he was not produced before the nearest magistrate within 24 hours of the time of his arrest, excluding the period of journey. It is contended that he is in fact produced on 30/3/2026, that is nearly about 72 hours of the date of his arrest. The petitioner has also contended that there is violation of the mandate of section 47 as well as section 47 of 48 of BNSS, resulting in breach of his fundamental right guaranteed under Article 22 within bracket 1 of the Constitution of India. Stop. Considering the contentions raised by the learned counsel for the petitioner, the perusal of case diary as well as the orders passed by the concerned magistrate on his first production after his arrest would be necessary. Hence, call for the scanned copy of the case diary as well as the said order. Let this matter be listed again.
My lord, can it be, because next week I have some matters, outstation matters in Silchar and Itanagar. So can it be on the 14th or 15th of this month? 14th or 15th? Even the public prosecutor would also get sufficient time. 14th of May, 14th or 15th?
Let this matter be listed again on
15th. Let it be on 15th, my lord, because next day, Saturday, I'll get one day break. Because I'll physically appear.
15th of May.
I'm deeply obliged.
List accordingly.
I'm deeply obliged.
Item 34.
May it please your lordship, I have already filed my power and the written objection is still under preparation. And however, due to personal difficulties, the respondent could not depose on the affidavit. And if your lordship may kindly grant 2 weeks' time to file the same.
Okay. This affidavit is against the condonation delay?
Yes, my lord.
Okay. What is your name?
Ram Murmu.
Heard Mr. Ram Murmu, learned counsel for the appellant. Also heard Miss, what is your name?
K. Nuke Sandy Rose.
K. Nuke Sandy Rose, learned counsel for the respondent, who submits that though the written objection to be filed by the respondent is ready, however, due to some personal difficulty, the affidavit could not be sworn in by the respondent, and on that grounds she seeks some more time to file written objection, the prayer is allowed. Let this matter be listed. How much time? After 2 weeks,
After 2
on a
weeks.
date to be fixed by registry. List accordingly.
We oblige.
Lordship, Part 2, item number 10, hearing list.
Yes.
Part 2, item number 10.
Yes. You are ready?
Yes, Lordship.
You are ready? Then I have
Part 2, item number 10.
May it please your Lordship.
Just a minute. Yes.
This is an appeal against judgment and order dated 25/1/2023, passed by Special Court Fast Track Additional District and Session Judge, Kolasip District, Mizoram, in criminal trial number 21 of 2022, wherein the present appellant, the accused, was convicted under Section 4 of POCSO Act, and he was sentenced dated